Your credit report can determine whether you get a loan, land a job, or secure an apartment. But did you know there's a federal law that governs exactly how that information can be collected, shared, and used? The Fair Credit Reporting Act, or FCRA, establishes critical protections for consumers and strict requirements for businesses. Understanding these rules can help you protect your rights and avoid costly mistakes. The Fair Credit Reporting Act was first enacted in the 1970s and updated to its current form in 2003. This federal law regulates how consumer reporting agencies handle your personal financial information. It creates a framework of rights for consumers and obligations for the companies that collect, report, and use credit data. Three main groups must comply with FCRA requirements. First are the consumer reporting agencies, commonly known as credit bureaus. The big three are Experian, Equifax, and TransUnion. These organizations collect and maintain credit information on millions of consumers. Second are the furnishers of information. These include banks, credit card companies, landlords, and other entities that supply data to the credit bureaus. Third are the users of consumer reports, such as employers, lenders, insurance companies, and landlords who access credit reports to make decisions. Consumer reporting agencies can only share your information when there's a permissible purpose. The law defines several legitimate reasons for accessing credit reports. Lenders can use them to evaluate loan applications. Employers can access them for hiring decisions, but only with your consent. Insurance companies can review them for underwriting purposes. Landlords can check them when screening tenants. Courts can order their release through subpoenas, and creditors can review existing accounts for collection purposes. As a consumer, you have powerful rights under the FCRA. You can access your credit report for free once per year from each of the three major bureaus. Additional copies cost less than $10. You have the right to know what information is in your file and who has accessed it. If you believe information is inaccurate, you can dispute it. The credit bureau must investigate your claim, typically within 30 days, and correct any proven errors. When someone uses information from your credit report against you, they must tell you. If you're denied a loan, rejected for a job, or turned down for an apartment based on your credit report, the party making that decision must notify you. They must also tell you which credit bureau provided the information. This gives you the opportunity to review the report and challenge any inaccuracies that may have influenced the decision. Employers face specific requirements when using credit reports for hiring or employment decisions. They must provide a clear disclosure that they may obtain a credit report. They must get your written authorization before accessing the report. If the credit report might lead to a negative employment decision, they must provide you with a pre-adverse action notice. This notice includes a copy of the report and a summary of your rights. Only after giving you time to respond can they take the final adverse action and provide a final notice. The dispute process is a critical consumer protection. If you find an error on your credit report, you can file a dispute directly with the credit bureau. The bureau must investigate, usually within 30 days. They contact the furnisher of the disputed information to verify its accuracy. If the information cannot be verified or is proven incorrect, it must be corrected or removed. You can also dispute your credit score if you believe it's calculated incorrectly. Information furnishers have their own set of obligations. Banks, lenders, and other data providers must report only accurate and complete information. When a consumer disputes information, the furnisher must investigate within 30 days and notify the credit bureau of any inaccuracies. They must update or correct previously reported information found to be wrong. They cannot report debts discharged in bankruptcy as active obligations. These requirements help maintain the integrity of the credit reporting system. Credit bureaus often sell consumer names and addresses to marketing companies for pre-screened credit offers. However, you have the right to opt out of this practice. By calling 1-8885-OPT-OUT, you can have your name removed from these marketing lists. This reduces unwanted solicitations and provides additional privacy protection. Enforcement of the FCRA falls to several agencies. The Federal Trade Commission and the Consumer Financial Protection Bureau oversee compliance at the federal level. State attorneys general can also take action for violations affecting their residents. Beyond government enforcement, consumers can file private lawsuits for FCRA violations. Penalties can be substantial. Statutory damages range from $100 to $1,000 per violation. Courts can award actual damages for financial harm caused by violations. For willful non-compliance, punitive damages may apply. Successful plaintiffs can also recover attorney's fees and court costs. While the FCRA provides baseline protections nationwide, many states have enacted additional consumer protection laws. California requires extra disclosures and offers free credit freezes. Vermont mandates express consent before pre-screened credit offers. New York limits how long certain negative information can remain on credit reports. Both consumers and businesses need to be aware of applicable state laws in addition to federal FCRA requirements. Accessing a credit report without a permissible purpose is a serious violation. Curiosity is not a valid reason. Personal relationships don't justify access. Businesses must have a legitimate need tied to a transaction or decision involving the consumer. Unauthorized access can result in civil liability and regulatory penalties. Companies should implement strict access controls and train employees on permissible purposes. For businesses that use credit reports, compliance requires ongoing attention. Develop clear policies and procedures for obtaining, using, and storing credit information. Train employees on FCRA requirements and permissible purposes. Implement systems to ensure proper disclosures and authorizations. Establish processes for handling disputes and adverse actions. Regular audits can identify compliance gaps before they become legal problems. The FCRA creates a balance between the legitimate needs of businesses to assess risk and the fundamental rights of consumers to privacy and accuracy. Whether you're applying for credit, seeking employment, or renting an apartment, your credit report plays a significant role. Understanding your rights under the FCRA empowers you to ensure the information used to judge you is accurate and handled properly. For businesses, compliance isn't just a legal obligation, but a matter of maintaining trust and avoiding costly penalties. The FCRA framework protects the integrity of our credit system and ensures fairness in how financial information shapes important life decisions.